I'm just going to hit record. So welcome everybody to the Working Towards Restoration webinar and research study. My name is Susan Collings and I'm a research fellow at the Research Centre for Children and Families at the University of Sydney. And I'm here with my colleagues, Betty Liu, Amy Conley Wright, Sarah Sitsky, Irene Wardle, and also Meredith McLaine. And we're delighted you could join us today for your lunchtime webinar session. Without further ado, I'd like to welcome Irene Wardle to give the Acknowledgement of Country.
Thanks, Susan. I'd like to acknowledge our traditional custodians on the land in which you are all residing. For me, it's Duncan country on the Central Coast. It is important to remember the traditions, values and beliefs of my ancestors as you carry out your work in the field of child protection. Our kinship is unique and all is interconnected to support the customs and traditions we hold dearly, the raising of a child. I welcome you today into my kinship network to share your knowledge and learn from one another as we do when with family. As a grandmother, mother of 5 and auntie to many, remember you too are part of an extraordinary group of people working to make this world a better, safer place for children. I want to share a story that is significant in the work that you do and to understand the importance of Aboriginal stories in relation to the complex system we call kinship and cultural responsibility. Particularly now with the emus and the rain. Aboriginal people know that it's going to be a cooler, wetter summer if the emus lay their eggs continuously throughout the summer months. And it only happens in this weather pattern we have now. Most of us know that it's a La Nina weather. In direct language, we call it Jumu. November this year is a very significant as we have not had this weather to increase the emu fertility cycle for just on a decade, when emus seemingly breed twice in a single year. As emus normally only breed once a year in April to June in an El Nino year, normal winter pattern. Although they can continue the breeding process continuously from November to March, in this weather we are experiencing now, female emus do breed more than once in a cycle, can produce as many as 50 chick eggs. It's a dark green eggs called a clutch and usually numbering between 5 and 20 is laid by the female but cared for the male. But after 7 eggs, the male gets broody and sits on them for the entire incubation period, rarely and reported not at all, leaving the nest to eat and drink. However, the female, on the other hand, leaves the nest, after which she shows no more interest in her partner. She shows no further interest in her eggs, either as she knows that the father will meet his responsibilities. She will wander off to join a group of non-breeding birds or look for another male and mate again. Sometimes first-time fathers will get so excited about fatherhood that they will harass and even chase off other fathers and steal their chicks. This results in a super brood of up to 50 chicks. The significance of this story is that each parent is unique and has the potential to go either way in raising a child. It can take a stronger mentor to guide and support that parent, or sometimes take another in the kinship system to step into the role of both parenting and mentoring of the child and the new mum or dad. As our belief systems work, each parent is unique and not necessarily from the same egg, but the nurturing of the child is everyone's business. And today we come together to share knowledge and kindness. Without kindness, we forget that the heart of our work is with children. And to be authentic and true in raising a child, kindness is at the centre. So be a broody male emu parent, stay focused, work tirelessly and collect as many chicks as you can to improve their lives. I personally thank you for the compassion and strength you all demonstrate to improve the lives of many children. There you go.
Thanks so much, Irene. That's a beautiful start to today's webinar. I also wanted to acknowledge the image you can see on the screen, which was produced by our colleague, Associate Professor Lynette Riley. It's called The Tree of Knowledge, and she's not just an Indigenous scholar and leader of Indigenous education, but also an artist. And we're very fortunate to to have her beautiful artwork. And you can also see the link to her kinship module at the bottom of the screen. So please look that up for those of you who haven't had a chance to do the module. So today we've got just under an hour together, and I'd like to welcome first the Director of the Research Centre for Children and Families, Associate Professor Amy Conley Wright, who'll be setting the scene and telling us about the evidence, the permanency reforms in New South Wales, and also the evidence review and the permanency practice framework that have come out of those reforms. And then Dr. Betty Liu will be sharing what we know about evidence-based practices that support restoration, and followed by Meredith McLaine, who'll be talking about court decision-making in care and protection, which is her PhD, part of her PhD topic. And then you'll be invited to stay on for a focus group as part of the Working Towards Restoration study. And we'll be giving you some details about that at the end. But without further ado, I'll hand over to Amy.
Thank you, Susan. And I would also like to acknowledge the traditional owners of the land on which I'm joining from today, the Wadi Wadi people of the Darwal Nation, and pay my respects to elders past, present, and emerging, and any Aboriginal colleagues who are with us today on the call. So just as we start off, I'm just going to give a little bit of a context around the New South Wales permanency reforms that provide the context for the evidence review that Dr. Betty Liu will share. So if you could go to the next slide. Thank you. So this will be familiar to many people, but I'm just going to kind of give a bit of a high-level overview of some of the legislative changes that have occurred in New South Wales over the last decade. So sort of in the last decade, starting with the Safe Home for Life reforms, there's been a major time of change in the child protection space, and a real sort of sharpening and focus on the concept of permanency, legal permanency. So beginning with the Safe Home for Life reforms in 2012, a report was issued about the outcomes of a public consultation on the child protection system reforms called A Safe Home for Life. The report spoke of a need for sweeping reforms to the New South Wales child protection system, including the streamlining of open adoption processes and other methods to get children home and stay home with family. In 2014, in response to the Safe Home for Life report, legislative reforms were made to the Children and Young Persons Care and Protection Act of 1998, and to a lesser extent, the Adoption Act of 2000. And the main changes were the inclusion of the permanent placement principles, which prioritized legal guardianship with kinship or foster carers, or for non-Indigenous children, open adoption with foster carers over long-term foster care, i.e. care of responsibility to the minister to 18 when there's no realistic possibility of restoration, and also introduced specific timeframes about restoring children to their parents using that sort of standard of realistic possibility of restoration, which Meredith will speak to. And in 2015, New South Wales government commissioned an independent review into the out-of-home care system, otherwise known as the Toon report. The Toon report found that the long-term and intergenerational needs of children and young people were not being effectively met, as there was an over-reliance on crisis prevention and the reduction of immediate harm at the expense of interventions which had more long-term goals, and that this was especially true for Aboriginal and Torres Strait Islander children, and that there was a need for a whole of systems reform. And in 2017, the New South Wales government introduced the Permanency Support Program to improve the accountability of out-of-home care services. And a major part of this was changes to the contracts of out-of-home care services to commission for outcomes, sort of using this new outcomes-based contracting and funding system to incentivize non-governmental organizations that managed out-of-home care placements to find children a permanent home within 2 years of entering care, either through restoration or through other forms of legal care. So that's sort of the legislative context of what we'll be discussing today. If you could advance to the next slide. So the practice framework that was developed, was developed in this context because of the major changes that are happening in the out-of-home care sector, that the out-of-home care sector is shifting over the last decade from providing a safe placement to actually providing outcomes in the form of getting children back home through restoration or supporting guardianship or open adoption placement. And so this is requiring major practice changes in NGOs, and the need to look at what are the practices that actually have some evidence behind them. So in 2019, the Permanency Support Program Practice Framework was launched as a co-design process led by the Parenting Research Center with 3 NGOs, Wandiali, Care South, and Benevolent Society, with an evidence review and a process evaluation conducted by the Research Center for Children and Families. And all of this is funded by New South Wales DCJ. The intention of the practice framework is to use evidence, and you'll hear about the evidence review in a moment, and a co-design process with those 3 NGOs to identify specific casework practices that can be used to support restoration, guardianship, or open adoption for children. And we will be doing a process evaluation after this is the initial pilot is completed, so that we can provide some learnings to other NGOs that want to take up this practice framework. Could advance to the next slide. So the Permanency Practice Framework is about practices and approaches for supporting parents and carers to have the required parenting support, skills, and confidence to offer this permanent home to children through restoration, guardianship, or open adoption. So the practices are about working with the parents and the carers. It's not a sort of systems level type of practice framework. It's about the specific actions that caseworkers can take when they are working with parents and carers, so that those parents and carers have the ability to offer that long-term and stable home to children. So the evidence review that Dr. Betty Liu will share with you in a moment examines practices that build the capacity of the adults who care for children. And we look at different strategies that have succeeded in terms of the evidence that's out there. And this review has informed the work that PRC is doing with those 3 NGOs to inform the practice framework that they're developing, which really very much focuses on coaching, which is one of the types of evidence that we identified in the review. So having given you that bit of background about the evidence review that you're going to hear, I'll now hand over to Dr. Betty Liu. Thank you.
Thanks, Amy. I will be providing an overview of the method and the review that we conducted about evidence-based practices to support restoration. So please advance the next slide, Susan, please. Thank you. So this review is a systematic review that sought to assess the current research that was known about permanency programs across guardianship, adoption, and restoration. But for the purposes of this talk, we'll focus only on the practices that we identified from the restoration programs. So it involved a detailed search of published and grade literature for programs that have been evaluated using what we would consider rigorous methodologies, that is experimental, quasi-experimental, and pre-test, post-test designs within various countries which have similar systems to Australia. And we had a very specific time frame. Given the number of programs out there, we constrained it to the last 20 years, basically. So in order to give you a good understanding of the kind of, the way we approach this review, what we were really hoping to do was to look through all these programs and try to identify discrete practices that caseworkers could use with parents in supporting reunification efforts. And the point of it is, by the end of this review, we wanted to compile what I would consider as an analogy, a kind of playlist of kind of reunification or restoration practices that are shown to be effective, right? So it's like, the greatest hits of restoration practices. Because what we did was, we did this wide search. We threw everything that we could based on these targeted searches about restoration. We did some sorting and then, decided what was in and what was out of this playlist. And then we went in and kind of listened to every song, every program to understand what makes these programs work and what kind of, things these programs are targeting, and identifying these kind of elements that are common across these different songs or programs. And the idea is to kind of go into this deeper analysis to identify these high quality, what elements are common, and then coming up with this, what makes these songs so good? What, if it was going to be a good restoration program, what kind of, parts of a song would they consist of? So hopefully that gives you an idea of what we were trying to achieve from this review. Next slide, please, Susan. So as I said, we were trying to focus on very discrete approaches, kind of concrete skills and kind of practices that could be undertaken by caseworkers to help parents. And we will focus on these kinds of outcomes related to stability of the placement, security, in kind of feeling a sense of belonging and relationships for the child, and obviously safety as well, being protected from any instances of abuse and neglect. So grey literature is kind of like the unpublished thing. So, in our kind of academic world, we focus a lot on kind of peer-reviewed electronic databases that are kind of published and have gone through a rigorous peer review process. But grey literature can be things, and thanks so much, Judy, for talking about that. That's those things that might be government reports or kind of other reports that make it into that peer review, but still might be of very high relevance to stakeholders. So we try to cast a very wide net to try to figure out what's out there, because that's the point of a systematic review. Rather than just us picking certain things, we cast the net very wide and then try to sift through everything to find what was the best quality evidence we could rely on. Thanks, Susan. So if you're familiar with systematic review processes or not, as they're very systematic, as they say. They go through a very screening process. We go through thousands of different search results. We go through screening to make sure the study is relevant or not relevant, and then we go in and kind of take a deeper dive into these articles to unpack what kind of programs they are, what outcomes they're targeting, how these programs are done, and by who, and with who. So we kind of went through a very extensive process, and in the end we had a whole bunch that we excluded because they weren't kind of relevant to the scope of our review about reunification practices or restoration practices, sorry. And then we ended up with 12 articles to include, which documented 10 specific programs that we found to have a kind of high evidence rating, and also were targeting these outcomes related to safety, security, and stability for children. Thanks, Susan. This art diagram is a way of just illustrating the different ways that we could kind of look at these different articles, right? Because there's different levels at which you can assess things. You can assess it at the level of the research, as in like the methodology. Was it, a kind of rigorous experimental design? Was it quasi-experimental or pre-test, post-test? So you can make some evaluations about the design of the study and say whether it was rigorous or not. At the second level, you can look at the intervention itself. So you look at assessing the intervention, what kind of outcomes it was targeting, the design, who's the target audience, and the kind of key results. And then the third one, which is this common practice elements that I will be elaborating in a moment, it's about looking at the level of the different practices that make up those particular programs. So really drilling down to those practices to find out what are the practices, these kind of building blocks, make up this particular program. So next slide, please, Susan. And hopefully this elaborates this common elements approach a little bit more in kind of unpacking the different elements of practice that are based within programs, because you have different interventions, right? And they are targeting kind of common, specific outcomes related to restoration, safety, security, stability. And what we find is over time, when you review these interventions, there are certain, certain practices, certain approaches, certain kind of, I would call building blocks that make up these programs. So the idea is to kind of synthesize across all these different interventions, what are the kind of common elements of practice that we're seeing that seem to be having an effect on an outcome that we're interested in. So it's also a way to, for practitioners themselves to also consider in using the findings of our review to consider whether if they were to see a program, whether that program would be effective, because does it contain the kind of practice elements that we've identified that seem to have, a kind of effective kind of influence on an outcome that is effective. And the other benefit to this is it's a way of particular caseworkers to kind of tailor their practice and take certain kind of bits from different programs, these different common elements approach, and kind of tailoring it for the audience, a particular client, and the parents to look for certain outcomes. There's a bit of flexibility which has a benefit over kind of those manualized programs that kind of get imported from overseas, and they can be quite costly and take quite a bit of resources to implement. So it's a kind of much more flexible way of just doing practice, caseworker practice within reunification, and kind of just more tailoring, more flexibility, and just ensuring it's based on something that is supported by evidence. Thanks, Susan. So within our review, we found that we identified these common elements of practices within restoration programs. We found 8, And, it was a bit of an iterative process because certain programs might do similar things, but they just have different names. So, Susan, Amy, and I, we kind of just talked through it and tried to kind of, identify the different bits and then start grouping them. So we found on the left-hand side, these are the program names of those restoration programs. And on the diagram, it's the those common elements of practice that we identified. So, there's stuff about awareness raising, it's about caseworkers working with parents to raise, the parents' awareness of, the origins of different types of behaviours, or, why children behave a certain way that they do. There's parent training, which is about, building skills and teaching parents about, how to, about discipline and maintaining boundaries and rewarding positive behaviours. There's parent homework where parents are encouraged to trial the kind of practices that they trial with the caseworker, but trialing it within a familiar environment in the home. Parent coaching came up quite a bit, as mentioned earlier. It's really about kind of having a structured interaction and where the parent can, try, certain kind of activities with their child, but with the support of someone, usually the caseworker, in providing some feedback and some support for maintaining some good interactions. Goal setting was also a big one in terms of, speaking with parents and helping them understand, and talk about what they want to achieve in terms of the restoration, and breaking that down into smaller steps if needed, and supporting them through those various stages and goals. There's also role modeling, which was also very prominent across all these programs about, caseworkers modeling good behaviors. If it's a program that involves other parents, kind of setting up this environment where everyone works as a role model for parents to see, how to, behave positively and have good parent-child interactions. Building motivation was also important in terms of building that engagement with parents and motivating them to change. And finally, parent partnering, which also was about foster carers also playing a role and being like a partner to that parent and supporting them as a bit of a mentor. It might have been the foster carer, it might have been another trusted person who could kind of support the parent in their reunification, restoration efforts as well. So this is kind of a bit of an overview. Next slide, please, Susan. And in this review, once it's published, we're close to publishing it now, there will be some information about these different common elements of practice that I've just talked about, and an explanation. And what I have here on the right-hand side is EXP experimental design, QEXP quasi-experimental, and PTPT is pre-test, post-test. So this is just the different level of rigor that these programs were evaluated at, whether it was evaluated in a randomized control trial that was experimental or so, and just indicating what it's trying to do is just tell you, where the evidence lies. And you can see that for the most of these have been evaluated under what we would consider a rigorous experimental design, especially coaching, awareness raising, training, role modeling. They all seem to be very part of the greatest hits of restoration practices. And I think I have some examples next, Susan, if you'd like to advance. Yeah, so parent coaching, as I elaborated earlier, and in this review, goes into some summaries of and examples of what these different practices look like. So parenting coaching, aiming to observe and reinforce parent-child interaction skills, as I said, might be a structured interaction. There might be observations made by the caseworker behind a mirror or, in live with the parents, or they might be communicating via a wireless device or within a support group. So really just finding ways to provide feedback before, during, and after an activity, and helping parents problem solve and learn techniques, and help their child lead during play. There's different programs in that use this kind of parent coaching practice. Next slide, please, Susan. There's, as I said, goal setting, which is supporting parents to identify specific goals to address parenting problems and supporting them through that. So skill building, reinforcement, monitoring of progress, and it features in programs such as IRP and KEEP, Intensive Reunification Program, and KEEP. And next slide, please, Susan. And finally, building motivation, which aims to encourage parental motivation to change and improve their engagement. So, kind of building that level of trust and empathy, and exploring, kind of motivation to change as well as resistance to change, and building those collaborative relationships, which seems to be really important in that caseworker and parent practice when we're talking about restoration, which featured quite prominently in a program known as Home Builders. Yeah, so I think that was mostly it for now in terms of our very extensive review on reunification practices. So I will now hand over to Meredith McLaine, who will talk about an excellent literature review that she conducted. Thank you.
Thanks, Betty. So some of you already know me. For those that don't, as well as being a PhD student, my day job is a lecturer at Wollongong University. And I was a solicitor for about 25 years, including several years specialising in care. The program for today says that I will tell you about the evidence on judicial reasoning in restoration. In a nutshell, that evidence so far is very minimal. Excuse me. And I'm in the quite early stages of trying to fill that gap in knowledge. So the focus of my presentation today will be on emphasising that it is a gap and some very preliminary tentative findings from my research so far. My apologies, I'm having a croaky throat. So my topic is judicial interpretation and application of the statutory realistic possibility of restoration test in care proceedings in New South Wales. And primarily I'm aiming to do that by thematically analysing the content of decisions, judgments in contested restoration hearings. Now, so far I've only been able to access the published judgments, so those that are on Children's Law News or sometimes in Case Law New South Wales. Specific to restoration, there are, as you can see on the slide, only about 25 such judgments over a 10 to 11 year period. About half of those are judgments of our outgoing President of the Children's Court, Judge Johnston. Now, these are, of course, an extremely valuable resource, but that relatively small sample, I think, doesn't necessarily reflect a wider cross-section of what the various Children's Court magistrates are doing, the approach that they're taking to these hearings on a possibly weekly basis in courts across the state. So for that wider perspective, I'm hoping to access a sample of the unpublished reasons for decision, 25 to 50, perhaps more. And as many of you will know, the hearings are all audio recorded within the courtroom, but they don't ordinarily exist in written form unless a transcript has been ordered for some particular reason. I note that last year's Families Culture report recommended that all final hearing judgments should be in written form and publicly available. And the argument there was that that's in the interests of the transparency of the system. But as it is, that's not the case. And I've experienced some logistical and human ethics delays in accessing those judgments. I acknowledge the help of Kathy Samuels, who I think is in the webinar today, Director of Child Protection at DCJ, and others of her staff, and also the court itself in the assistance that they're giving me in the rather challenging task of trying to pinpoint the cases that went to hearing on restoration and to locate those recordings. Next slide, please, Susan. Okay, legal framework. An audience of lawyers can probably see that what I've got on the slide here is somewhat oversimplified. There are many more provisions of the Act that are relevant, but at its essence, I'm looking at Section 83, whereby the Secretary must make a determination as to whether there is or isn't a realistic possibility of restoration, having regard to the circumstances of the child, the evidence, if any, that the parents can address the issues that led to the removal, and then since our last round of significant amendments, that restoration being possible within a reasonable period up to 24 months. Then we've got the body of case law precedent around this issue that tells us that a possibility is something less than a probability, but must be practical and sensible, not merely fanciful or based on unlikely hopes. Then there are a few cases delivered by Judge Johnston since the amendments that came into place early 2019 that tell us that possibility should be based on the commencement of or commitment to a cohesive, coherent, viable plan. I don't have it on the slide, but I should add that he's also said that that plan should enable continuing success to be confidently predicted. And then with all of that, we've got the unacceptable risk of harm test, essentially imported from the family law jurisdiction. Now, I would assert that this body of precedent is expressed in very abstract terms. And that, of course, is appropriate to enable these broad principles to be flexibly adapted to each individual set of factors in a particular case. But unless you're a very experienced care practitioner, I think this broad body of principles makes it difficult for an onlooker or a participant, a parent, another party, so forth, to be able to have a clear sense of predicting what this parent needs to do or how is the court likely to view the situation, what is the priority, and so forth. Next slide, please. Okay, so what existing literature, research-based evidence is there? So in Australia, it's definitely an under-researched area, but a gradually growing area of interest, I think. So there's a body of studies that have looked at particular perspectives on the overall, the whole court process, and I won't read through them there. Some examples are there. And then there's another group of studies that, rather than looking at the overall legal process, are honing in on a particular procedural aspect or a particular part of the legislation. So placement, decisions, contact, Section 90, and so forth. With those, there haven't been any studies that I can find that are looking specifically at the decision on restoration or its interstate equivalence. Some of those studies will refer to the outcome on restoration, but as incidental to their particular focus. None of them are really honing in on the judicial reasoning and the statutory interpretation that informs that fundamental outcome. Is the child to be restored to birth family or placed in long-term care? Next slide, please. So at an international level, there's also a modest but growing body of research on various issues, including several quantitative studies that look at the correlation between risk factors and other variables and the court outcome. Now, those studies are really significant and important, but a finding of a correlation between a particular factor and outcome doesn't really tell us what the underlying reasoning is for that correlation. So the statistics can tell us the what, but not so much the how and the why. With methodology, both in Australia and internationally, we see predominantly interviews, focus groups, surveys, including hypotheticals and direct participant observation. Far less common are studies that have accessed the court case files. And as I've got on the slide, it is rare that studies have accessed the judgments as distinct from other documents on the case file. And very rare are studies that have qualitatively analysed the judgments, which is what I'm wanting to do. So in the Australian context, I've only found 2 Australian studies that have thematically, qualitatively analysed judicial decisions in care. One is by one of my supervisors who's here today, Judy Cashmore, who looked at how magistrates are using social science expert evidence in care decisions. And another study by a Bryony Horsfall in Victoria, who accessed some unpublished written decisions in her study on children's participation and the role of the independent children's lawyer. Next slide, please. This slide is listing some of the big picture conceptual themes that reoccur across the literature in this area. Now, I don't have time today to address any of these specifically. Suffice to say that each one is very interesting when delved into. I suppose I would note that generally, when dealing with a specific individual case, a children's court magistrate is unlikely to be explicitly referring to and exploring these conceptual themes, but I think it's safe to say that most, if not all of them, are implicit and inherent, buried within the approach that the particular judicial officer brings to the exercise of discretion, to the balancing task that's involved in care decisions. Next slide, thanks. So here I'm honing in on some of the more specific issues that are common across the research in court decision making. And these can be grouped into three categories. The first A are the parent characteristics or circumstances. So mental health, disability, family violence, etc. you can see there. Now, these are all extremely relevant and important to parenting capacity and risk of harm to the child, but I'm calling them parent characteristics because all of these could exist irrespective of or independent of the particular child who's an issue in the case. Then we've got B, the factors that are specific to the particular parent-child relationship or the allegations of child maltreatment. And then C are the child characteristics that are specific to the particular child. And one of the things that's interesting here in the research is that certainly, at least from the legal angle, I think it would be different in the social science child protection literature. But from the legal perspective, category A receives by far the most attention. And that's in the literature, and there are some suggestions that perhaps reflects the court decision-making process or the sort of evidence that is before the court. This is fairly contentious, and there is some Australian research that certainly indicates that magistrates place enormous attention on child characteristics like safety and stability. But there are some other research suggesting that the legal process focuses on parent deficits, particularly with insufficient attention to showing a clear causal link between those parent characteristics and the parenting relationship and the impact on the child. So that's one of the things that I'll further explore. Next slide, please. Okay, so my last few slides are my attempt at some pretty basic quantitative analysis arising out of the published judgments that I have looked at. So the first slide is showing you from the magistrate's perspective the dominant reasons for the initial removal for the case being initiated. And this is measured by the emphasis placed by the magistrate, measured by frequency of reference. So this could be different to what's on the department's case file or what's on the initiating application documentation. But in terms of frequency of emphasis for the way the magistrate is delivering the narrative as to the background to this case, you can see that domestic violence is certainly the leading factor. Then we've got generically neglect, and then we've got parental mental health concerns coming in as completely equal, and substance abuse is number 4. There are, of course, innumerable other factors, but I'm just putting the top ones on the slide. Okay, the next slide, Susan. So this is turning to the dominant reasons for findings that there is a realistic possibility of restoration. Again, measured by the frequency of reference. I had expected to be able to pinpoint the main reason in each judgment for the outcome. That's proved really elusive and virtually impossible because, as we know, a judgment is not presented as a scientific formula, and the way that the reasons for decision are structured and delivered are extremely variable. So it makes it quite difficult to be able to say, here was the main reason. So again, it's sort of more loosely based on how often the magistrate refers to a particular issue in what appears to be they're talking through their reasoning. So we got insight appearing here as the main reason. Then we've got substance abuse being addressed, followed by mental health being addressed or progress there, and domestic violence addressed. Coming in at number 5 is attachment. So this is an example of what I was referring to earlier, where it's not until we get to the 5th most dominant reason that we have something that would fall within the parent-child relationship category. These other 4 reasons are all particular to the parent, a parent characteristic. Next slide. Thanks, Susan. Okay, so these are what I'm finding to be the dominant reasons for a finding that there is not a realistic possibility of restoration. I think there's a few interesting things here. We've got mental health concerns jumping to the top, almost equal with lack of insight. And substance abuse drops off completely, which is I wouldn't have necessarily expected. It's down at about reason 9 or 10. The other, I think, particularly interesting thing here is that of these 5 leading reasons for refusing restoration, 3 are about parental attitude to the removal or the proceedings themselves. So lack of insight, lack of candour, and being non-compliant. So on the next slide, if you want to move to that, Susan, I have combined all the parental attitude categories, consolidated them here. So that's lack of insight, lack of candour, lack of compliance, hostility to workers, and not accepting responsibility. When those are consolidated, you can see that they far outstrip all the other factors. So more than double the next area of concern of mental health concerns and the others that you can see there. And Sarah has asked, what does lack of candour refer to? Sarah, lying, being dishonest, or being perceived to be evasive with the truth. Yeah. Okay. So this dominance of poor parental attitude is consistent with some research, particularly coming out of Victoria, a couple of related studies where the researchers retrospectively applied some risk analysis tools to outcomes, to court outcomes. And they found that other factors such as mental health, domestic violence, and substance abuse had little to no statistical bearing on the outcome if measured independent of their connection to non-compliance or to compliance. So I hope that makes sense. So one way they put it is that the impact of substance abuse is negligible unless measured in terms of its impact on compliance. I hope that makes sense. Okay, and then my last slide. Some of the key emerging issues from this. Mental health is so prevalent in both reasons for restoring and not restoring that perhaps raises some issues about how the legal system is diagnosing, evaluating mental health, and there's some research that suggests that it's quite vague in the way child protection workers and the court does that. So could we be doing better in terms of supporting and resourcing parents in that area? Insight, compliance, and the related characteristics, how are magistrates conceptualizing and determining those issues? And how does that sit and fit with the substantial body of research that says that parents feel very alienated by the proceedings? There could be some interesting connections there. Then more broadly, risks and deficits versus parental strengths. That is then linked to that issue of, is there a focus on parental deficits with insufficient attention to causal links to the actual impact on the particular child? So these are just some of the things that when I have access to a body of the unpublished reasons for decision, I hope to be able to explore. How did I go for time, Susan? All right. I was
brilliantly
rushing.
well.
There were a few other things I could have addressed, but I can save that for questions if need be.
Well, that's right. So we've now got, thank you so much to all our speakers, Betty, Amy and Meredith, finally. And that's been really illuminating, particularly Meredith's presentation, which we haven't seen before, and I think has raised some really juicy questions. Amy has been taking note of those questions that have been coming up in the chat. And because you did so well, Meredith, with your time, and I know you had to cut to get it into time, we hope you are able to see if Amy comes on and has a look at them.
But we don't have any questions at this point, so people can start putting them in the chat. But I thought that I would just put one to Meredith and maybe to our research team. I think it's really interesting reflecting on Meredith's findings, from the published judgments, and then looking at the evidence review. The practice framework that's being developed actually really does focus on attitudes in a sense. I mean, it's around motivations, skills, and goals, that we were looking at. So interestingly, I mean, it might sort of suggest that, using these practices with the NGOs might enhance sort of judicial views on parent motivation if they're implemented by caseworkers. So I wondered if Meredith wanted to share any views on that in terms of the practices that we identified in relation to parent coaching, goal setting, building motivation, and how you think that they might relate to some of your emerging findings.
I mean, I think they absolutely have to, as long as that parent is seen to have complied with directions to attend, participate, and complete that program. And I guess no matter how good the program is, some of the problems that we come up against as parents, lawyers, a perceived lack of commitment to that. And from many perspectives, the response to that would be, well, so be it, and that parent doesn't have appropriate insight. But I guess there are bigger questions around some of the parents feeling adequately supported around a genuine engagement in those programs, or they may feel they have engaged, but in some way that's not translating. One of the issues in terms of insight is that it's, as I've written in my literature review, insight is in the eyes of the beholder. So participants in the court system will tend to greatly measure insight by the presentation of the person in court and how they behaved in the courtroom, whether they attended and so forth. And that could be very different to how that particular parent views their own insight, or how a worker delivering a parenting course perceives insight. So, yeah.
Thank you. Yeah, and you can imagine that parent coaching might actually be prompting some insight and encouraging kind of a readiness to change, that in the absence of some support like that looks like parent coaching, you might not see. And actually we have a question about parenting coaching, and then we have another one about parent attitude. So I'll put these questions to you, Meredith, the ones we've got. So question for Meredith: does parental attitude also refer to perception as to how well the parents have engaged with DCJ and other service providers?
Yes, I'm trying to think of my categories there. And my categories have been informed by what the magistrates and the judges are saying in their decisions. So one of the common categories is hostile conduct towards workers. So that would fit in with a perceived lack of proper engagement with the department or other programs. There's a lack of insight category broadly, because that's a phrase that's just so commonly referred to in the court decisions. So when I get a little bit more into a refined analysis methods, there are various subcategories of insight. I hope this answers the question, but yeah, it's all in there somewhere.
It sounds like, yeah, so part of it is about how much parents have engaged with DCJ and other service providers. Yeah.
So lack of compliance can also be melded with lack of cooperation. Okay. It's expressed both ways.
Can I just check in, because you did mention that there's a big, there's potential kind of overshadowing of mental health issues, and whether and the sort of lack of precision around, or consistency perhaps around, how that's being diagnosed and presented to the court. Maybe that also impacts on a sense that there's a lack of insight.
Yeah, absolutely. Yes. Yes. How can a person struggling with a mental illness
have insight? Yeah.
Or they may have it, but how are there interpersonal behaviours demonstrating that?
Yeah.
So we have another question about insight, and then we'll move back to the question about parent coaching. So what is the evidence of a causal link between observed or articulated insight and behavioral change? And perhaps is this a stay tuned question, because maybe this is something that you'll be looking at in the literature review part of your PhD?
I don't think that a causal link between insight and behavioural change. Yeah, I think the literature on the legal process tends to assume that there's an inherent link there, but doesn't analyse that with any level of specificity. And I guess that links to research on expert evidence and clinical assessments as to what level of precision clinicians are doing that, and there's some sort of mixed views and mixed research on that.
Yeah, I would just add too that there is a body of evidence about, well, it's some evidence about readiness to change, which goes beyond insight. I think it's also ready where people have made a decision about changing their behaviours. So in child protection.
Yeah, I mean, I think some of these questions are more for our social science specialists amongst us, child psychologists. Yes, I can really only focus on what's appearing out of court decisions, which is often lacks precision when it comes to these concepts.
Yeah, and let's address Lyndall's question, which I think actually can go to both Meredith and to Betty. So you raised parent coaching by caseworkers, this is in the review, and briefly touched on the role of carers, but were you able to look into the role that carers play in supporting restoration, and whether any of the restoration cases involved carers becoming a party to the proceedings? So maybe Betty can address whether we looked at any evidence that touched on the role of carers in supporting restoration back to parents. And Meredith, you can speak to whether there are any evidence in the restoration cases about carers becoming a party to the proceedings.
Thanks, Amy.
Yep.
I'll talk about that point about carers being involved. I think when we were doing the review, there were articles that talked about the role of carers, and I think there is a good basis to say that they play a really important role. Because of the scope of our review limited to the experimental design, quasi-experimental, and pre-test, post-test, we only ended up with one, which was like a parent partnering program, which involved like a mentor, which could have been the carer being involved and having that had been evaluated at that level of rigor. So I think this is also a watch this space kind of thing, because there was a lot of descriptive articles and like review articles talking about, carers being involved in contact and kind of, supporting the parent. So I think there's definitely things there. It's only at this point still at this kind of descriptive qualitative level. It just probably needs a bit more time, or maybe to be tested more locally, especially here in Australia. I think it needs a lot more local evidence. So I think there's a point at which those kind of evidence will start to emerge a lot more, and I absolutely agree that there is a role for carers to be played in supporting that restoration. Yeah, just for the purposes of our review and our scope, it just didn't make the cut into the playlist, but not to say that it won't at some future point.
And I'm just looking at my notes. So the role of the carer would tend to come into the literature and the decisions under that category of the child's circumstances. And so reasons for finding no realistic possibility of restoration, on my approximate data, I've got a risk to the child's stability coming in at about reason number 8. So reasonably high. So that's certainly where the courts are looking at the progress and stability of the child in their interim care placement and not wanting to disturb that. It's certainly there and it's acknowledged. And in terms of which cases, yes, there would have been cases, I can't name them off the top of my head, where the carer became a party. But I'm simply looking at the same body of published cases that many of you as lawyers in the webinar are very familiar with. So cases that you might know about where there's been a joinder of a carer, they're the same cases that I've looked at.
We might have time for one more question, if anyone has that before we close this up. I note that Professor Judy Cashmore put a comment in, as long as they can get access in the prescribed time and address the issues that may be long-standing or difficult to turn around, substance abuse and mental health. Do you want to comment on that at all, Meredith, around access to services around those issues? Did that come up as being an issue?
To
support substance abuse treatment and mental health issues?
Absolutely. So amongst the big picture themes that I had on the slide, there's an enormous area of the research literature reflecting sort of some quite polarized views and tensions between a parent's rights, an approach that recognises structural social inequality and real problems in accessing programs and so forth. A lot of the literature discusses that, and it tends to be somewhat pitted against what's perceived as a child welfare, child-focused need for swift permanency and stability type approach. And I think polarising those is absolutely oversimplifying things, but there's certainly some tension amongst scholars about sort of which perspective they're coming from and going into that for parents. I'm not sure if that wasn't quite phrased as a question, Judy, but I hope that sort of is what you're referring to.
And we might, thank you, Meredith. We might, conscious of we're approaching the 1 o'clock end of our time together. So I just wanted to once again thank our speakers, Amy, Betty and Meredith for today, and also to all of you for joining us. This webinar has been recorded, so we will be sending it out to people who registered and then weren't able to make it. And if you've registered for let us know that you'd like to join a focus group, that'll be starting. There's time for you to go and have a break and comfort break and get a cuppa. And we will be coming together at about 5 past, and you'll be broken up into small groups. But we also just wanted to say that after this webinar, you will be getting a follow-up email with the recording, the link to the recording, and also a link to a survey. So if you can't make it to the focus group, where we'll be digging into some of these issues that have been raised today in a bit more depth, and looking at some of those things that came up right at the end there around social inequalities and barriers to getting the support in a timely fashion to meet these kind of now restrictions around the 24 months. So we'll be digging into that a bit more deeply, but you will also get an opportunity to do a survey. That is it shouldn't take too long. It can be a little bit challenging because it is a forced choice survey. Asking, and what we're trying to do is to get a sort of a consensus across a range of different professional perspectives about the most kind of important things to achieving restoration, achieving a restoration outcome in the court. So please, if you have time to do that, it probably only takes 10 to 15 minutes, and we'd love to have as many of you complete that as possible. Yep, so unless there's anything else, Amy, you'd like to add, we will.
Oh, just to mention that the survey, yes, it uses Q methodology, which is the way it gets analyzed is using a type of factor analysis. So it sort of sees if there's clusters of viewpoints that are underneath the ways that professionals think about restoration. And that could really give us greater insight into this whole process. So we're conducting it with caseworkers as well as with lawyers to get a sense of how people view restoration, and if there are clusters in terms of those viewpoints. So it's kind of fun because you sort cards, but you might find yourself a little frustrated because you have to kind of decide which ones you agree with the most, which ones you disagree with the most. But ultimately it gives us some kind of feeling for how people place those cards and those contain statements about restoration.
And we think it's a pretty novel way to Meredith's obviously contributing a great deal to our evidence here in Australia, and this is another contribution to that. So you'd be really helping us learn a bit more about what professionals view as being the most, I guess, significant, or what those common viewpoints are around restoration. But it's now 1 o'clock, so we'll move on to the next stage and let you get back to the rest of your days. Thank you all so much for joining us.